Welcome to our webinar today. My name is Natalie DePaulson and I am a member of the Trademarks Opposition Board. My role at the Opposition Board is split between working on opposition and Section 45 case files and working on new policies and procedures at the board, including the focus of today's webinar on confidentiality orders, costs, and case management. I have two other colleagues joining me on the webinar today. Nina Kushwaha is the chairperson of the Opposition Board, and Eva Hefi is a fellow member, and they will be managing the chat. If you have a question, please feel free to use the chat feature. If there is time, we will answer the questions over the course of the webinar and at the end. If we are unable to answer your question during time constraints, we will ensure that the answer is included in a questions and answer document posted on our website. Finally, I confirm that participants will receive a copy of the slides next week. I also wanted to mention that the trademarks regulations we're going to be discussing today were recently published in Canada Gazette Part 2, and our practice notices are also available on the Trademarks Opposition page of CIPO's websites. Links have been shared in the chat. On April 1st, amendments to the Trademarks Act and regulations will come into force. This webinar will briefly review each of those amendments and then focus on three areas of significance for the Trademarks Opposition Board: confidentiality orders, costs, and case management. These three powers will be used in opposition, Section 45 cancellation, and objection proceedings before the board. Relevant sections of the Trademarks Act and regulations, as they will be on April the 1st, are on each of the slides. We have also included some alerts and tips in yellow. In 2018, Canada's intellectual property strategy was announced, with two of its pillars being making IP disputes more efficient and underlying the importance of use in the trademarks regime. On the basis of the IP strategy, a series of amendments were made to the Trademarks Act in Bill C-86, which was part of a budget bill. The Budget Implementation Act introduced changes to the official marks regime, in proceedings before the Opposition Board, in enforcement proceedings, and in appeals at the federal court. On each of these slides, we will briefly review the changes. There are new sections concerning official marks in the Trademarks Act. They are sections 9.3, 9.4, and 11.01, as well as section 26.1 of the Trademarks Regulations. The changes with respect to official marks will allow those applying for a trademark registration to more effectively overcome objections on the basis of official marks by providing a mechanism through which the registrar can give public notice that the mark that was the subject of a public notice of adoption and use as an official mark is that the entity is not a public authority or no longer exists. These sections are responsive to concerns that the protection provided to official marks was overly broad and will facilitate overcoming objections in examination raised on the basis of an applied for mark being mistaken for an official mark. Section 11.01, which isn't included on the slide, confirms that use of an official mark under Section 9.1 and 3 is not prohibited if the entity that requested the official mark is not a public authority or no longer exists. There are two changes to the Trademarks Act that will impact enforcement actions and depreciation of goodwill, and then appeal of TMOB decisions. These new sections are at sections 53.211 and 56.5 of the Trademarks Act. The first is the requirement to show use in enforcement proceedings if they are begun within the first 3 years after registration. The changes to the Trademarks Act requiring that use be shown in these proceedings to enforce a registered trademark within the first 3 years reinforce the importance of use in the trademarks regime, as discussed in the intellectual property strategy. This amendment to the Act ensures that registered trademark owners use their trademarks in Canada before attempting to enforce their registered rights in court. It is limited to 3 years. since after 3 years, the defendant may commence a summary Section 45 cancellation proceeding to have a trademark expunged from the register if the owner has not yet used the trademark. The second change in proceedings before the federal court is that the Trademarks Act is being amended so that on appeal of a registrar's decision, leave to adduce further evidence or evidence that was not before the registrar is required at the federal court. This is to avoid a situation where parties put limited evidence in at the opposition stage or on a Section 45 proceeding, for example, and then put further evidence in at the federal court, which was available at the time of the proceeding before the board. It is the hope that this section will result in more efficiency and have disputes fully adjudicated with available evidence at the first opportunity. I do want to highlight something here. With respect to appeals of trademark opposition decisions, it is important to note that this provision only applies to applications advertised after June 17, 2019. Any trademark applications advertised before this point have the old Act govern. There are very few cases before the Trademarks Opposition Board that were advertised before June 17th, 2019, but I wanted to mention it because there are a couple there and there are more on appeal for the federal court. So one further change to the Trademarks Act is to put in a new provision allowing for an objection or an opposition to be deemed withdrawn if the registrar is in the opinion that the opponent or objector is in default in the continuation of that proceeding. And so I'll give a little background. For many years in opposition proceedings, if there is an opposition where the applicant has filed a counterstatement but has filed no evidence or written submissions and does not request a hearing, the Trademarks Opposition Board has sent the applicant a letter requesting that it confirm that it is still interested in the application. If no response is received to that notice, the application was treated as abandoned pursuant to Section 36 of the Trademarks Act. The amendments to the Act at 11.13 and 36.1 will allow the same treatment if an opponent, for example, has filed a statement of opposition but has not filed any evidence or any written representations or asked to attend a hearing. We will ask them if they are still interested in the opposition, and if no response is received, may treat the opposition as withdrawn. So now we are on to the meat of the webinar and the 3 changes that are coming into force on April the 1st. Over the last few years, the TMOB has been working on modernizing its operations in a variety of ways. We've moved towards becoming a fully electronic tribunal by receiving evidence electronically and having cross-examinations and hearings largely being held virtually. These 3 changes brought about by C86 to give the registrar authority to cost awards and issue confidentiality orders, as well as to put into the legislation the power to case management, were also put in place for the board to increase its efficiency and to continue to modernize the tribunals. So the first area we'll look at is confidentiality orders. So to set the stage for confidentiality orders, Canadian courts have repeatedly indicated that judicial proceedings are open to the public, and it is important in maintaining the impartiality of tribunals and public confidence in them to have them open and the reasons for decisions available for the public to have the ability to understand and criticize decisions. That being said, there is a recognition that sometimes there is a competing public interests that need to be protected by having some information filed in proceedings be kept confidential. As of April 1st, the Trademarks Opposition Board, like courts and many other tribunals in Canada, will also have the power to grant confidentiality orders. Confidentiality orders will restrict the public's access to specific confidential information that a party chooses to file as evidence with the board. These are different from protective orders, which are used when a party has concerns about disclosure of confidential information to the other party. For example, what someone might see issued in a court during a discovery process. So ours are really focusing on keeping the information confidential from the public. So as of April 1st, as long as the evidence hasn't already been submitted, a confidentiality order can be sought for the filing of evidence with respect to objection, opposition, or Section 45 proceedings. This includes proceedings that are already ongoing. And as per the amendment to the Act, it's important to note that a party must file their request for a confidentiality order prior to submitting the evidence. Once the evidence has been submitted, the registrar is precluded from granting a confidentiality order and protecting it from public view by virtue of Section 45.12. The process for obtaining a confidentiality order is detailed in the trademarks regulations and in the practice notice on confidentiality orders. So the first thing that will happen is a party will file a request that evidence be kept confidential, and the practice notice indicates that parties are welcome to include a request for an extension of time of 1 month to file evidence after the registrar makes its decision on the confidentiality order. If the other side has not consented to the confidentiality order, the registrar will seek the comments of the other side and provide a deadline for a response. After considering the other side's submissions, or if no submissions are received by the deadline in the notice, the registrar will issue a confidentiality order or refuse the order and provide reasons in either case for doing so. There is specific information that must be included in a confidentiality order, and this information is set out in section 95.1 of the trademarks regulations. So the first thing is a request must contain a description of the evidence that the party wishes to be kept confidential. So for example, in a Section 45 proceeding, if that's customer names and addresses on invoice, so something to identify the evidence at issue, a statement that that evidence or information has not been made public, the reasons why that evidence should be kept confidential, and an indication of whether the other party consents to the request. And that last requirement is just to assist us in knowing if we are to request the other side's comments or we can move forward with considering the order. There are two important things to note here. The first is the request and comments are available to the public, so no confidential information should be included within them. The second is, as per the 45.12 of the Trademarks Act, do not submit confidential evidence before an order is granted. Once evidence is submitted, the registrar no longer has the power to issue a confidentiality order to protect it. Section 95.12 of the Act notes that in deciding whether to make a confidentiality order, the registrar must consider the public interest and open and accessible proceedings. In our practice notice, we draw attention to the test that's set out in Sherman Estates and Donovan in the 2021 Supreme Court decision, and the three elements that a tribunal or court focus on. And the first is that the openness poses a serious risk to an important public interest. And it's important to note that a public interest must be identified and protection of an individual commercial interest is not necessarily sufficient. So important public interest recognized in other cases, including protecting fair competition and personal information. The second element of the test is the order is sought is necessary to prevent that risk because reasonable alternative measures will not prevent it. So in terms of reasonable alternative measures that the Trademarks Opposition Board may consider, the primary one would be redaction. As you all know on the call, we have a long history of accepting evidence that has been redacted for confidentiality concerns, so long as we could understand it and make the appropriate inferences from it without seeing that information. So one of the things we would be assessing in the test is whether redaction is a reasonable alternative measure that could be used by a party. For example, if a confidentiality order was sought to protect the names of customers and their addresses on invoices, the same example I gave previously, this part of the test would ask whether redaction of the customer's names and addresses would be a reasonable alternative measure instead of granting a confidentiality order to perhaps protect those invoices or at least the names. Finally, the last part of the test looks at the benefits of the order outweigh its negative effects. And whether or not the benefits of the order outweigh its negative effects, we'll consider whether the information sought will not prevent the public sought to be protected, will not prevent the public from understanding the dispute, and the interest that the public has in accessing the information to understand the decision and the proceeding before the board. So this would be a relevant consideration. So we have a few suggested practices for requests that may assist the registrar in assessing a request for a confidentiality order. The first is to clearly identify the public interest at issue. Again, this needs to be something beyond the commercial interest of keeping, for example, sales information private. There must be a discussion of a public interest. The second is to keep the information proposed to be kept confidential to a minimum. For example, asking just the confidential parts of the document to be protected as opposed to a whole exhibit or affidavit. And the third is to draw the registrar's attention and explain why, for example, redacting the information is not reasonable in the circumstances. Lastly, it would be helpful for parties to identify why the benefits of the order outweigh the negative effects. In this regard, in certain cases, there's going to be a clear interest in the public understanding the decisions of the TMOB when it comes to, for example, finding a trademark is distinctive on the basis of a certain level of sales or on a level of consumer impressions through advertising, and the proportionality of the issue of the proportionality of the decision, including the ability of the public to understand it with the confidential information removed, should also be addressed. So if the confidentiality is granted, the registrar will prepare a model order. This model order is included as an annex to the practice notice, and it will also look familiar because it is based largely on the federal court model order. So first, it will set out how documents including confidential information should be filed. At the coming into force, this will be through paper and a corresponding public version. So that would be the version of the document that will be put on TSDR. And so that would likely include redactions, or if it's an entire page, empty pages indicating that that page is protected by the confidentiality order. And at this point, I'll pause and note that the order will not only cover how the affidavit is submitted, but if that confidential information is included in subsequent documents, so for example, cross-examination transcripts or written arguments, then the order would apply to those documents as well, with a public copy being filed, as well as a copy being filed, at least it coming into force in paper to the board in a confidential manner. The model order will discuss who is able to see the confidential information, including the parties, their agents, consultants, and foreign agents. It will include a limitation that the confidential information obtained is just to be used for the proceeding. It also will provide a mechanism for the registrar to make confidential documents, which include information but are mistakenly filed. And finally, it will provide once a final decision is issued and the proceeding has been concluded, including all appeals, that the confidential information should be destroyed, with the exception that agents may keep a copy. And I will note here that if you become aware that confidential information has inadvertently been included in a public document, please raise this with us as soon as possible. The trademarks regulations also allow the registrar to amend or revoke a confidentiality order, and there are a couple different scenarios where this may arise. First, if in a case there is a confidentiality order in place and further evidence is sought to be filed confidentially, the parties and the registrar may decide that it's more efficient to amend the initial order to add additional material and have a single order govern the proceeding as opposed to issuing multiple orders. The second is with respect to revocation. A party may request to seek to have the confidentiality order revoked if the evidence has become publicly available. I also want to highlight Section 45.1, 5D of the Act, which provides that the registrar shall take measures to ensure that when documents containing confidential information or a copy of them are sent to the federal court. And I wanted to note at this point, most notice of appeals of decisions that we receive, either on opposition or Section 45 hearings, include a request that the registrar send the certified tribunal record. We will, in cases where there is a confidentiality order at issue, send the evidence, the certified tribunal record, including the evidence, 15 days after it's requested. But it is important to note that if there's a confidentiality order governing the board will send the information in a confidential manner, but once it arrives at the federal court, that those files and annexes are publicly available unless a confidentiality order has been obtained from the federal court. So the reason why we've said we will send the certified tribunal record 15 days after it is requested is to give the party whose confidential information is included time to address this. And there's a few things that we want to highlight. And the first is Rule 318.2 of the Federal Court Rules, which allow a party to object to the certified tribunal record being transmitted. And the section is Rule 151, which discusses motions for confidentiality.
Hi, Natalie. We have a question from one of the audience members about obtaining extensions of time to file a request for a confidentiality order. So first, will there be fees for this extension of time request? And also, will it be granted automatically or depending on certain reasons?
Well, so the request to file a confidentiality order, the extension that would be sought is really one to your evidence deadline. So that absolutely does include a fee. And with respect to whether the fact that a request for a confidentiality order may be made at a later date, I would encourage people to contemplate that at an earlier basis, because if an extension of time is given, it's certainly not going to be 3 months or a longer time. We really do want to keep proceedings moving, even in cases where there are confidentiality orders. So there is no separate deadline to request a confidentiality order. It is really the evidence deadline that's at issue. And so lastly, we'll highlight that for enforcement of the order, reference should be made to Part 12 of the Federal Court rules that deal with enforcement of orders. And to do so, it's just required that a certified copy of an order may be filed with the federal court. And of course, that can be requested from CIPO like any other certified copy of a document. And finally, I'll note it's important to note that a violation of a confidentiality order can form the basis of a costs award at the TMOB. So before we move on to costs awards, I'll just canvass if there are any other questions with respect to confidentiality orders.
No more questions from the chat.
Thanks, Ev. So we'll move on to costs awards now. So we'll provide a little bit of background about costs awards. So costs awards were introduced as part of the IP strategy to make intellectual property disputes more efficient broadly. And so how costs awards have been formulated at the board are to provide and incentivize parties to efficiently advance proceedings before the registrar. They differ than costs, for instance, at the court that are intended to compensate a party for success in the proceeding, and they are not intended to prevent a party from participating fully or having zealous representation. The costs awards, they are on request. The registrar will not be awarding costs on its own initiative. They must be requested by a party in a Section 45 or opposition proceeding. And the registrar really believes that these are exceptional type requests that refer to more exceptional types of behavior. And so one example where you can see trying the attempt by the board to incentivize parties to efficiently advance proceedings and limit resource spend and delay for both the other party and the registrar is that, as we'll see, one of the costs awards that can be made is on the basis of canceling a hearing with less than 2 weeks before the hearing date. So this is something that causes unnecessary expense to the board and the other party in terms of maybe wasted preparation. And so the costs are aligned with that to incentivize parties to move forward with to efficiently advance the proceedings, even if the cost requests themselves may add a additional period or step within certain proceedings. So there are two circumstances that are applicable to all proceedings that may form the basis of a costs award if one is requested. The first I just mentioned is late cancellation of hearings. And I just wanted to say at this point, this is not if it's requested that a hearing be rescheduled or adjourned. It's really the cancellation of the request or cancellation of attendance to be heard. And the cost for that is 2 times the official fee to commence the proceeding. So roughly $2,000 if it's an opposition proceeding. I saw that there was a question in the chat about a tariff. And really for our costs, you'll notice at the different, depending on what the costs awards are, we'll note this is 2 times the official fee, one is 10 times the official fee, 5 times the official fee. So once the registrar decides that the conduct has occurred and a cost request has been filed, the amount that will be awarded is the amount that's set out. So 2 times the official fee in the case of late cancellation of a hearing. It is not the same as a tariff. That doesn't represent a maximum or minimum amount. That will be the amount. The second type of cost award that is applicable in Section 45, opposition and objection proceedings, is for unreasonable behavior that causes undue delay or expense in the proceeding. And the cost award that attaches to this is 5 times the official fee to commence the proceeding. So for unreasonable conduct and in determining whether there was undue or delay or expense in the proceeding, the registrar will have regard to the overall context, including the nature and purpose of the proceeding, the length and the cause of the delay, and the extent and causes of the expenses incurred by the other party. These factors aren't exhaustive, and additional context can be considered in a particular case. The following examples are included in the practice notice and give some examples of what the registrar may consider to be unreasonable conduct causing undue delay or expense for one or both parties in a proceeding, failing to attend a hearing or cross-examination without informing the Trademarks Opposition Board or the other party, or canceling a cross-examination on short notice without consent, failing to follow a case management order or direction, breaching a confidentiality order, a lack of cooperation with the other party for scheduling a cross-examination, pursuing a ground of opposition that has no reasonable chance of success, acting disrespectfully or maligning the character of another party. And I just want to refer back to a few slides ago that we really do regard these as exceptional. And it is not that these examples are often occurring in proceedings. Cost awards are intended to be an exceptional remedy for unreasonable conduct that does cause undue and delay in respect. And at this time, it's not something we're seeing in most cases. So that leads into minor issues are unlikely to result in a cost award. And again, if costs are awarded on this basis, the cost award will be 5 times the fee for if it's an opposition, a statement of opposition. There's circumstances that are applicable only to opposition proceedings. And one of the pillars of the IP strategy, as you'll all be aware, was reducing possible bad faith applications. And this has been reflected in the fact that cost awards are available where a bad faith ground of opposition succeeds. If costs are awarded on this basis, the cost award will be 10 times the statement of opposition. For divisionals is another area where there can be an inefficiency introduced where there's the filing of more than one divisional, so say multiple divisionals. And in this case, if a divisional is filed on or after the day on which the original application is advertised, there can be a cost award of 2 times the statement of opposition fee. There's an important note here. In the practice notice, clarifies that the registrar will generally not award costs in cases where only one divisional application was filed on or after the date of advertisement. And the reason behind this is because the registrar believes that the filing of one divisional application may assist in settlement negotiations and allow for a subsequent withdrawal of the opposition against some goods or services. So in that way, if you have one application and take out the goods or services that you believe that you could settle on, then the registrar will generally not award costs on that basis. It is really looking at when there are multiple divisionals filed. And if costs are awarded for that, the cost is 2 times the statement of opposition fee for each divisional application after that second one. So for the filing of a request, costs must be filed using the General Correspondence tab of the TMOB e-services. And the deadline for filing the costs differs slightly as if there is a hearing requested and there is no hearing requested. So if neither party has filed a request for a hearing, or both parties have filed a conditional request for a hearing, or one party files a conditional request and the other party does not request a hearing, in all 3 of those cases, the registrar treats that file as if no hearing has been requested. For those cases, the deadline to request costs is 14 days after the deadline for requesting a hearing, and a single extension of time of 14 days will generally be granted. If either or both parties request a hearing, a party may file a request for costs within 14 days, either after the hearing ends or the day on which the registrar notifies the parties that the hearing has been canceled. A request for costs must include the reasons for the request and the particulars of the circumstances for which costs are sought. It also allows the services supporting documentation. If you would like to attach supporting documentation to a cost request, say your cost request is on the basis of issues with scheduling a cross-examination, and that's not information we would have in our files, then that supporting documentation can be included. Cost request should include the particulars for the basis. And for some of these types of cost awards, they're going to be very brief. For example, if there is a late cancellation of the hearing, then really it is the original hearing date and the date of cancellation is the information that the registrar would need to make a determination on a cost award. For bad faith, it would be simply the bad faith ground of opposition at issue. For divisionals, the original application number, when the divisionals were filed, as well as their application number. And I should mention this time, our e-services, similar to the statement of opposition e-services, actually prompts people to provide this information. So you will receive those prompts as you're moving through. The one that is a little more complex is for if on the basis that there's unreasonable conduct, and the request should contain sufficient details of the unreasonable conduct or alleged unreasonable conduct at issue, and the manner in which the conduct caused undue delay or expense to the party in the proceeding. Documentation supporting the request can also be filed. There is no requirement for the documents supporting a cost request on the basis of unreasonable behavior to be filed by way of affidavit or statutory declaration, but a party may wish, if they wish to do so, they're welcome to do so. We have a few suggested practices for unreasonable behavior. And it's to start with throughout the proceeding to identify where the other side's conduct is causing undue delay or expense. And that will draw the board's attention to those files and these instances. Consider the issue of consent to extensions of time. Detail why the behavior is unreasonable and connect it to the undue delay and expense. And it would be very helpful to understand how the conduct of the other side lengthened the proceeding. For example, if there's an unreasonable request for leave to file additional evidence, and additional evidence time is required for cross-examination of the affiant, and to detail what expenses were incurred. For example, late cancellation of cross-examination may unnecessarily incur witness prep costs and court reporter costs, and All of that information will help the registrar assess whether undue delay or undue expense was incurred as the result of the unreasonable conduct. And so on the next slide, we set out the process for cost requests through to a decision. So the first will be to file the request for costs, including all of the information that was set out for the particular type of cost award to be sought. Then the registrar will seek the comments of the other side. When the other side submissions come in, the registrar will consider the request for the cost awards and the submissions. And as part of the final decision in the proceeding, or the registrar's final decision in the proceeding, will include reasons refusing for a cost award, or if a cost award is granted, will include an order that costs be paid in a particular amount from a particular party to the other party, the time for payment, and the reasons for granting costs. If an order is to be filed for enforcement of costs, that occurs at the federal court. And again, it's Part 12 of the federal court rules.
Hi, Natalie. Another question from the chat. Given that the costs are based on the fee for initiating the procedure, or the proceeding, pardon me, then which fee will it be exactly? Will it be the fee in that particular file, or the fee which is current that at the moment that the award is granted? So given that the fees increase with every year.
Let's return back to it, and I appreciate that question. We'll clarify that in the practice notice.
Excellent, thank you.
Yes, so it's a good time. So some of the questions that you raised today, we will make clarifications to our practice notice, and so you may see some small changes based on the webinar today. We had a webinar yesterday in French, and so this will be one thing that we will clarify in the practice notice is the timing of that fee and which fee is chosen. So there are some transitional provisions that deal with costs throughout the regulations. And so these appear within the regulations themselves. There's no separate section labeled transitional provisions, but they appear within the cost section. And so the first thing is that for cancellation of a hearing, costs will only be incurred for hearings scheduled after April 15th. And I took a quick look, and it doesn't look like there are any scheduled between April 1st and 15th. So it's really only cancellations of hearings scheduled after April 15th that could potentially attract a cost award. For unreasonable behavior or unreasonable conduct, that conduct has to occur after April the 1st. So with a view to that, we expect it may actually be some time before a costs award appears in a decision on the basis of unreasonable conduct because of the fact that we're only looking at conduct after April 1st. For divisionals, this is divisionals filed on or after April 1st. And for a successful bad faith ground of opposition, that's for a ground of opposition included in a statement of opposition filed or amended on or after April 1st. And the reason for these transitionals is just the general principle that costs shouldn't be awarded for retroactive conduct or conduct occurring before that power is introduced. So really we're looking at April 1st and after. So I'll return back to costs and Canvas. Were there any questions on costs, or should we discuss any slides further?
Just one more question on costs. As part of your tips to the profession, you indicated that if a party it tells the registrar throughout the proceeding where there has been unreasonable behavior that caused undue delay or expense. That would be helpful when comes the time to request costs. How should a party be doing so?
So I think when we're highlighting that for, so oftentimes now when we look at requests for further evidence or amendments to statements of opposition and pleadings, we're indicating in the parts that look at the prejudice to the other parties that really there's no costs, that we can't award costs that would recognize or compensate a party for the delay or expenses they may occur. For example, if they have to cross-examine the same affiant again, or they have to file additional written submissions. And so it would be helpful when we put the call out for comments on those leave requests, if a party feels that there is some undue delay or expense being incurred, that they respond and mention that. We see that too, I can imagine in cross-examination, if you're requesting the registrar set a date for cross-examination and the back and forth to arrive at that point has caused undue delay or expense, certainly to highlight it for the registrar would be helpful.
Thank you.
And so, so case management. And so the last of the three powers to be discussed today is case management. And the reason why we put this one last is because it may be something that you are already familiar in seeing in part with the board. And so we have a long history of conducting case management pursuant to the common law principle that the registrar, when acting in a quasi-judicial function, is a master of his or her own procedure. And this has taken the format of holding one hearing for related cases, aligning deadlines for large groups of related files, holding conference calls, for the scheduling cross-examination issues, accommodations at hearings, and when there's been large number of files to be heard together, canvassing the issues that will be covered at a hearing. So case management's a little bit different than the other powers in that we do have a history of it at the Trademarks Opposition Board, but the regulations and act have put this into the legislation. And so the way that the regulations conceive of case management, or how it will be operating at the board going forward, is what we'll call the first type of case management, or 95.2, which is that in particular circumstances and with considerations of fairness permit, the registrar may make any order or give any direction that the registrar considers appropriate to deal with a proceeding in an efficient and cost-effective manner. And this really formalizes what the TMOB has been doing for quite some time. The additional power that the legislation gives is for where a proceeding requires a heightened and ongoing direction, the registrar may designate the proceeding as a case managed proceeding. And there's a list of things that the registrar will look at in deciding whether a proceeding is to be case managed, and that would be the procedural efficiency, the volume of evidence at issue or expected to be at issue, the complexity, whether the parties are represented, whether there's a number of related files involving the same or similar parties, and the amount of intervention by the registrar that the proceeding is likely to require, and whether substantial delay has occurred or as anticipated to occur in the proceeding. And this will give us the flexibility to tailor procedures and to vary the application of the regulations or adjust deadlines set out in the Act. This will definitely be in conversation with parties. And part of the reason for the more expansive case managed proceedings flows from some issues that may arise from the Madrid Protocol and divisionals. So case managed proceedings, one example. Sorry, I flipped. We've gone through these ones, but these are examples of where we may do one-off. I'll flip forward to the next example for a case managed proceeding. And so what a case managed proceeding will allow us to do, for example, that is to consolidate multiple proceedings. And so in respect of proceedings involving divisional applications, the registrar may order that the submission of documents be consolidated, such that at a party's election, the documents submitted in respect of the original application may be deemed submitted in respect of each divisional application. So this would permit an opponent to submit one statement of opposition against the original application or parent application and each of the divisional or child applications. It also permit a party to submit a single extension request, evidence, really all documents. We see that as advantageous for the registrar and the parties because as we arrive at the hearing, we'll have the same record perhaps for multiple applications. This may also assist where there are groups of related files where the advertisement dates of the related files maybe differ by a year. So if the parties are in agreement, this will give the way for the registrar to bring those later advertised related files and align them with the files that may be at the applicant's evidence stage, for example, and then advance them in one group through to final decision, and then have one group that if a further appeal is going to be filed so that it's all occurring at once. One important thing that the practice notice does clarify is that consolidation will not apply to fees. And I will return back because I had an example of a case management conference because at various times where we've met with stakeholders, it's been mentioned, well, when would we expect to have case management conferences? And one thing that's come up consistently is in cases where there's confidentiality orders, it may be helpful to have case management conference or further directions from the registrar as that case approaches conclusion. So the kinds of things that may be canvassed in a case management conference is what the procedure for the hearing would be if there are any observers or parties present that are not permitted to see, or in this case hear, the confidential information. Then it may set out that a breakout room would be provided. A case management conference may also canvass the procedure for decision if there's been a confidentiality order. So one potential being that after the hearing, the member issues the decision to the parties and asks for their comments on potential redactions to be included in the public decision. So this is one thing where we see a role for case management will be to have cases with confidentiality orders proceed with maybe some extra directions at the end of the procedure. So that actually concludes the webinar, but we do have a few minutes for questions and just a few minor housekeeping points. So the first is to remind everyone a copy of the slides will be sent to all participants. The trademarks regulations and the practice notices that were referenced today, you will have received a link in the chat, but they are all available now online. And a note, there may be some small amendments to our practice notices based on the webinar, but also after April 1st, as case law comes out from the board with respect to confidentiality orders and and cost awards and case management, you can expect that our practice notices will be updated and amended to provide further guidance as the board issues its own case law and decisions with respect to those powers.
Thank you, Natalie. I do have a question from the chat about a case managed proceeding. In a case where, as you explained, there would be alignment of deadlines and that that would mean that the deadlines would actually be extended. Can you clarify whether the parties will be expected to pay the prescribed fee for the request of an extension of time in a case where it is actually the case management that extends the deadline?
So typically we'll still be using section 47 for extension requests. Now, if almost all aligning of deadlines, if it comes at the party's request, there will still be a fee to be paid for that. If the registrar is issuing a direction on its own initiative, and people will have seen this now, sometimes if the registrar notices that there is cross-examination orders that have issued just a little out of sync, we will, on our own initiative, without payment of the fee, use our own discretion under section 747 to align those. So the plan is not to create two tracks where you have a kind of an extension of time track for deadlines using section 47 and the case managed proceeding tract for case management to also obtain proceedings. So that the times when a case management proceeding and the aligning of deadlines would really look at things like divisionals, certain issues that may arise with the Madrid Protocol, and same as it's done now, the registrars will use its own discretion under section 47 to align those. I don't know if that helped answer the question.
It was clear to me. I hope that it was also clear to the person asking the question. Perhaps one last question, because we only have 2 minutes. I just wanted to, yes, so here, can you clarify for the participants whether or not the board will be awarding costs against a successful party, for instance, in an opposition, because as you know, in the federal court, that's how it works, and that's not necessarily how we will do it here at the board.
Yes, that could happen. If a successful party cancels their attendance at a hearing within that 2-week period, you can imagine the other side requesting costs, and it is not the fact of success that would limit us, and it really is looking at those specific behaviors that tend to delay proceedings or incur costs. So cancellation of a hearing, the filing of divisionals, for example, those could all still incur costs even if a party was successful in the opposition, or I guess successful in defending their application.
Yes, thank you so much. So given that we have only a few seconds left, perhaps I will say that we have noted the questions in the chat, and to the extent that it is possible, we will amend the practice notices, as Natalie said.
Thank you very much. Thank you everyone for attending on a Friday afternoon. We really appreciate it, and we will send these slides out to you early next week. Thank you.